Hi everyone, Latrice Knighton here with Sterling TV, and today I'm interviewing attorney Dan Adams, who is a criminal defense attorney here in Milwaukee. And I've known Dan for a long time because we both were prosecutors in the Milwaukee DA's office. So I knew he'd be a great resource for you. You've been practicing criminal law for over a decade now, is that right?
Just about, yeah.
Okay. And so he now is doing criminal defense work, but his previous role in the prosecutor's office gives him a very unique perspective. He understands what the district attorney's office is looking at when it comes to charging someone with a crime. He understands and we'll talk a little bit about what deferred prosecution agreements are. So if you actually are being considered to be charged with a crime, there's ways if you hire an attorney ahead of time to actually avoid being charged and kind of come up with an agreement not to be. But he also just has a ton of experience. And Dan, I know you get a lot of calls from people kind of going through a breakup of a relationship or a divorce. So say we have a client who has moved out of the house, but there's some bad blood between them and their spouse. So they're texting each other and calling each other, and then now finally one of them's called the police. I mean,
right.
What should they expect?
Well, so in the divorce context, police are unfortunately involved more and more,
Right.
and I'm getting a lot of calls from people, and that's usually the context is during a breakup or a prolonged child custody dispute, and lo and behold, the police are involved. What people have to know is the first step is not to get, unless you're a victim of domestic violence, truly. The lesson is don't involve the police, because in Wisconsin there is a mandatory arrest law. So if you're just having a tit and for tat verbal altercation or whatever, and no one's actually at risk of violence, don't involve the police, because if you do, somebody's going downtown, and that's going to have the effect of making everything else that you're trying to work out in divorce court a lot worse. That being said, if you're in fear of your safety, call the police. And try to get yourself to a safe point before anything else happens. On the flip side, if you have the police come and you are arrested and you're charged with domestic violence, disorderly conduct, battery, God forbid, criminal damage to property, violating some type of court order, the first thing you have to realize is if the police are there, it's probably too late. You need to stop digging the hole. My dad used to give me great advice when I was a kid that if you find yourself in a hole, in life has dug you a hole, the first thing you have to do is stop digging. Unfortunately, when police are involved, people think they can talk themselves out of it.
Okay.
In Wisconsin, because of the mandatory arrest law, if they're there and someone called the police on you in a domestic situation, you're probably going downtown. So your best bet is probably to clam up, assert your Fifth Amendment right to wait and speak to a lawyer before you speak to the police. That way you're not saying you're not going to get your opportunity to tell your story or your side of the controversy. You're just waiting to do it in your best possible light with a good attorney by your side.
I do like your distinction right away, because there can be the tit for tat of someone wants a piece of property out of the house, so they want to grab their laptop and their spouse is not opening up the front door, or they want to change pickup time of the kids. I mean, those are disputes you should be talking with your divorce attorney, because we, as your divorce attorney, can reach out to the other side, if that person's represented, or their attorney, and say, hey, here's what the change is, and if that person doesn't respond, then we can go to court. But if there's any threats or any actual physical violence, that you need to actually call the police, because a divorce attorney can't help you with that. In your experience, when it comes to, say, someone filing a restraining order because they feel like their spouse won't stop calling them or won't stop demanding something of them or is threatening them, I mean, what is that process like? What should the person who receives a temporary restraining order do?
So mostly I'm on the defense side.
Right.
So one of my clients will be the respondent. They'll get this order. Knock, knock, knock. It's the sheriff deputy. You're not expecting this thing to come. It is a signed court order signed by a judge that says you can't talk to your spouse, your child's parent, this person that you have this great rapport with, who you've had a very emotional relationship with, and you're told stop right now, no more. And that's really tough for a lot of people because, again, they think, well, if I could just talk to him, we can sort this all out. Well, that's continuing to dig yourself into a hole. What you need to do is immediately call your divorce attorney. They may respond with saying, well, I don't do this, or call your criminal defense lawyer, and really be diligent about showing up, marshaling all of your facts, maybe text messages, maybe pictures of something that they had done, or some things that really throw into question their allegations against you, because these allegations are always domestic violence related, or harassment or stalking. They're really serious things. The problem is too many people just say, well, it's not real court, it's just restraining order court. They show up by themselves, they get called as a witness against themselves, and they go on and say stupid things that could be used against them in a criminal court or in a family court setting. And that's really something you don't want to have happen.
Now, in the pendency, because people dig themselves in a hole, I mean, what happens? Would it be used against as evidence if you continue to text once you get the temporary order?
Absolutely.
Or you email, or you use an aunt or an uncle to get a message through, and how will that hurt your temporary restraining order?
Well, one, you could go to jail. You get a TRO, temporary restraining order. The sheriff hands it to you. You've now been served. You're on notice that you can't have contact. No matter if you've been married for a year, 20 years, 25 years, you're now on notice you can't have any contact until you go to court and have your day, and that restraining order is either dropped or there's some conditions put on it. So the first thing you have to do is, again, don't try to fix it yourself. Call your lawyer. Get some advice about how you can have your side of the equation heard, and do it in the right way. I've had so many clients come to me and say, I just wanted to tell her I loved her, or I just wanted to tell him that, things were going to be okay, or we could work this out. And they end up having that sheriff come back again and lead them out in handcuffs, and they sit in jail for 3 days. And then you have the cost of a family law attorney. Then you have to hire a criminal defense attorney to try to deal with the issue as well. Beyond the cost, it hurts you guys, because you're supposed to be going in front of a judge and saying, hey, this is my client's a great person, great father, great whatever. The judge says, oh, well, what about this allegation of domestic violence?
Right.
It just kills you.
It does. I think it's also with domestic violence, you're looking for a pattern of behavior. So they're used to people who have been controlling, not wanting to listen to a court order. So I think it's not really, I think a lot of people don't understand that you're not listening to a court order, and the court finds that offensive, that they told you not to do something. So it's not just your spouse, it's also you're now not listening to a judge. And we hear often about continued contact and then state charges. And so there's typically a no contact order if you get charged with a crime in Wisconsin,
Sure,
correct?
right.
So a lot of people also don't tell their criminal defense attorneys about a divorce case. And so they get a no contact order with both the spouse and the child, just because they do the umbrella of everyone who's in the home. Have you had any experience in criminal courts being able to talk to a judge about not including the kids on a no contact order?
Oh, absolutely. The good and the bad of a bail motion and a bail hearing is that it's really a discretionary thing. So a court commissioner or the judge can really fashion a bail bond conditions however they want to. That gives you an opportunity to come in with extra information from your family law attorney. You've got placement of the child worked out, child wasn't there when the allegation happened, and really fashion something that's fair and equitable. And for the most part, judges don't want to keep you away from your kids. They understand, even if there is a fairly serious allegation, they really want the kids still involved in your life. So the big thing is to get in early and prepare and be deliberate about what you're going to ask the judge to do. I've had too many cases where right before court, someone says, oh, one more thing that I want you to argue. Well, that's not the right way. You should be having a conversation right when the offense is charged, and interface between your family law attorney and your criminal defense attorney, so everybody's on the same page, everybody's pulling in the same direction with as much good facts and evidence to persuade that judge to do the right thing.
So, and it's probably because we both practice this area so much, so I'm just going to give a little overview. So typically, at the same time that someone calls the police for someone harassing them, they will, the police will start state charges, and then at the same time the party may go after a temporary restraining order. And it's if you are charged with the crime, at the first hearing, which is called a bail hearing, the court will decide what the bail is. It'll be a cash or a signature bond, and then they'll have conditions. So while the case is pending, there's no contact order, meaning you can't contact either your spouse or your kids. So we're talking about, you need to let your defense attorney know while you're in court, that you don't want a no contact order for your kids, but you are fine with the one for wife. And why that's important, because in a family law case, if we start off with no contact, it's hard to start winning back more contact with your kids. And so from a divorce attorney's perspective, we don't want a no contact order with the kid, because it already starts limiting your placement time. And I think, especially in divorce, when there's kids, most parents want as much time with their kids as possible. So a no contact order can really harm your case of having placement time with your kids. It's going to be supervised, if anything, or not at all, because they're also not going to violate your criminal case. So I also want to talk a little bit about what happens prior to you actually being charged with a crime, so people understand what's going on in the background and ways and when to bring a criminal defense attorney. So after the police come to the home and they start taking reports, what happens?
So 911 is called, police show up, and any report of domestic violence is given a priority code by the police, so they're showing up. And their mindset is, if it's a domestic and there's any substantiation, which really means only one person is saying there's violence or threat of violence there, somebody's going downtown. So at that point, I would say, if you're the accused, just say, I'd rather talk to my attorney. You can, you do what you need to do, officer, but I would like to talk to my attorney. Now, at a certain point, you'll be brought downtown. You'll either have the ability to bail out. In Wisconsin, on a misdemeanor, there's a uniform bail schedule. You don't even have to go downtown to the Milwaukee jail. You'll be able to bail out from Franklin Municipal or West Allis or wherever. But you'll have a 72-hour no contact order, and that's just by law. So even though you haven't seen a judge, you haven't seen anybody, the police may still be writing their reports and investigating. There's still 3 days, no contact, no question. So you'll have to, at that point, start interfacing with your attorneys and see what the next step is. And really, at that point, a good attorney can get involved while the investigation is still happening and help the police to understand your side of the story. Now, unfortunately, most people don't do that. They wait until the police reports go to the district attorney's office, where we used to sit and review reports. The district attorney's office looks through the reports and says, well, I'm going to bring this as a state charge. Again, that's where you really want to be ahead of the game and have your attorney in the room to be able to lobby on your behalf to say, hey, maybe a diversion agreement or a deferred prosecution agreement or a no action and no process on the case is the best situation. If your attorney's not there, or if the evidence is too strong against you, a charge will be issued and you'll be given another date to come to court. Where you're going to get that formal bail bond with no contact order. And then from there, it just goes through the court system, eventually, hopefully, resulting in a good outcome for everybody involved.
Right.
But really, the name of the game is to get in early, to get your facts produced, but you really don't want to do it yourself. Because again, if you as a layman come in and say, well, I can explain exactly what happened, well, the police may cherry pick what you say to build a charge of disorderly conduct or some other thing against you, where really, if you had clammed up and just bided your time, there may be no charges.
Right. So the way to not get any charges is what you just said, not to talk and say...
Well, one, act like a gentleman or a gentlewoman at the beginning.
That's true.
Divorce is a highly emotional time, and any time you have child custody or property division, emotions of a long-term relationship going south, of course, people say regrettable things. But you don't need to text them. You don't need to, if you're not getting the response, to continue. And you certainly never put your hands on somebody else. That's the best way to keep out of this conference room.
I think emotions do get high, and it's because people aren't used to having all these different emotions and the breakdown of a relationship. I mean, when something breaks apart, it's hard to try to pull it all together. But I agree. don't send the text, send an email to your attorney complaining about how horrible your spouse is. Just don't do it, because texts are evidence, Facebook's evidence. Anything that creates a record is evidence, and then if it's a phone call or someone sees you acting that way, clearly that's a way to get charged.
And I will say, when we were in the district attorney's office, we didn't see text messages.
No.
Now every single domestic violence charging conference I'm in, the DA has 1, 2, 3 packets of text messages. Oof. And nobody ever looks good in them.
No.
And you can cherry pick them and sort them in terms of the most terrible things someone has said. And in a vacuum, that can be really bad for someone.
And I've even seen, through to the divorce process, I've had spouses be charged with crimes making computer threats, because the police now have, I'm assuming, even small units who can kind of track, I think it's IPN, on each computer, and see, even if you don't include your name on the bottom, but they have an idea that you're going through a divorce and you're upset, they'll just start kind of tracking all the stuff if your spouse complains. So I think there's technology, and the police are probably a lot more ahead than people are thinking.
And by the way, if you're arrested on a domestic violence charge where the phone is evidence, they're taking your phone. They're not going to give it back until the case is done. And by the way, when they download your phone history, they're downloading all of it. Oof. And they're going to look through all of it. So if you don't want the government to have your phone, don't engage in that conduct on the front end.
I agree. And there are good resources. I mean, I suggest a lot of times when people are struggling with the divorce and they're getting upset and they kind of can't control, even if you're just sad, it's good to see someone, like, for individual counseling or therapy. There's nothing wrong with it. They're not going to be used against you in court, but it's a way to decompress and get those feelings out so you're not involving the system. But if the system gets involved, you were talking earlier about diversion, deferred prosecution, and just no charges. When does any of that happen? Why would the DA even consider that when they have a police report right in front of them?
Sure. So, again, they're making their decision not just on the police report, but also the information that you can bring to them. And through an experienced and skillful attorney, you can present yourself in your most favorable light. And what the DAs are looking for is, how do we improve public safety? How do we make sure that this doesn't happen again? That's always their number one goal. I know it was ours when we were in the DA's office. So they're going to see if the allegation is really serious. I mean, if somebody gets clobbered with a baseball bat, you're not going to get any type of nice deal like that from the opposite. But if it's yelling at each other, causing a disturbance, something of that nature, and it hasn't happened before, there are 3 real good options. The best is to say to the DA, listen, this is a one-off thing. It's a de minimis conduct. It won't happen again. Give us a warning, or send it back to the municipality for municipal citation, which is just a fine. It's not a criminal offense. That's option 1. Option 2 is, okay, there was something serious here, but this person is a good individual. Let's enter into a diversion. And that's a pre-charge way of saying, okay, if we go to counseling for 6 months, there's no other conduct like this, we can come back and just not charge the case at all. We can just close out the books. And that's becoming more and more popular around Wisconsin. The last option is also a good option, but it does carry a charge. The DA says, I'm going to charge you, but we're going to walk into court and we're going to enter into a contract called a Deferred Prosecution Agreement, a DPA, and you'll do the 6 months of counseling. We'll come back to court and we'll either dismiss the charge outright, resulting in no criminal conviction, or we'll reduce it to this municipal citation. The problem with that is you still have the public stigma of having been charged with domestic violence. Still, all 3 of those are good outcomes, because the alternative is you get stuck with a domestic violence conviction, and there are all types of things that go along with that. One thing people don't realize is even a misdemeanor, disorderly conduct, domestic violence conviction results in you not being able to own a firearm for your life. The Violence Against Women Act, passed I think it was in the early 90s, makes it a federal crime if you have had a substantiated conviction for domestic violence. You can never possess a firearm again. So, there's huge collateral consequences, not just for yourself, but I can't imagine the family law context as well.
Right. And, it's been a while since I've been a prosecutor, so I may have even actually said DPA wrong earlier. But I think really what the takeaway is that the district attorney's office is really only interested in doing any of these diversions, deferred prosecution cases, or no charges. I mean, if this is, like you said, a one-off, like this hasn't happened before, because if you've had any behavior, even if there's citations, because they have access to all that information, they're less likely to do that. And so the repercussion is, again, you have a state charge, which makes it hard for you to find a job. You can't ever own a gun. It will affect your divorce case. The court will take seriously any claims of domestic violence, especially if you're charged, because that's in a way just automatic to them, and you're found guilty or you admitted and pled guilty. To them, that shows that there was some level of you being out of control. And so, especially if the kids were around, or you have kids, they want to make sure you can control your anger. So the list of things you end up having to do, both in your criminal case and then your family law case, just exponentially increases when you get charged or involved with any type of investigation. Now, I know you do more than just domestic violence, and some of our clients also, either they are or their spouse is dealing with alcohol or drug addiction. So, say you're charged with an OWI, what do you think people can do to, number one, the first offense is a ticket still in Wisconsin, but the second offense, you start looking at mandatory jail time.
Mm-hmm.
And some people want to minimize the number of days in jail because, again, they're working or they have families. If you're charged with some type of crime like that, dealing with alcohol and drugs, what can you do?
Sure. About half of my practice is alcohol and drug related things, and frankly, the domestic violence stuff has a lot of overlap with that. About 50% of every domestic violence case also includes alcohol. The lowering of inhibitions also makes people do regrettable things. Let's just say that. If you find yourself charged with an OWI, a lot of people on these first offenses think, oh, well, it's not a big deal. I'll just wait to pay the ticket later. I say never do that. The minute you get out of jail, and you will have paid, they'll either let you out after 12 hours, or you can use this uniform bail schedule to bail out for, different municipalities have different amounts. But immediately you should call a lawyer and say, hey, I got arrested. Here's what happened. Can I just walk you through the facts and tell me whether or not you think I can challenge my arrest for OWI? The big thing is you're still going to have a driver's license revocation for at least 6 months, where you're going to have, depending on your blood alcohol, you could have one of these interlock ignition devices, which is, if you've ever seen the movie The 40-Year-Old Virgin, it's a major issue for anybody who's driving. The stigma and the kind of embarrassment, not to mention it costs about $1,000 a year to install. The other thing is you'll have an occupational license for at least 6 months, where you're only told you can drive for these amount of hours. That's a huge thing for your liberty. Now, if you're involved in Uber, Lyft, if you're a postal worker, God forbid you have a CDL, those are big issues that you have, even a first offense, you have to address very deliberately and proactively. So in Wisconsin, there's a 10-day waiting period for the administrative suspension of your license on a first offense. But you have the opportunity to intercede and say, no, don't administratively suspend me. I want to have a hearing on that.
Okay.
And so there's a notice you have to send within those first 10 days to stop that automatic suspension of your license. People often call me on the 12th day, the 14th day, and they say, well, I don't want my license suspended. And I say, well, it's too late. We can fight the case, but your license has already been suspended for that period. So I guess the name of the game is be proactive. Nobody likes going to jail. It's really embarrassing. You got to kind of get your bearings again. What's going on? How did that happen? But through this process, talking with a good attorney who does a lot of these cases will help you through that process.
And I think even for our family law actions, number one, it's never good to even hear that you're arrested for OWI, but I don't even know, sometimes with, the pickup times and the placement times of kids, if you're charged with such a crime, people of course aren't going to want you driving. I mean, that's what your spouse is going to say. I don't want you driving with the kids. You're just
Right.
charged with OWI. You are, if you miss that 10-day window, but you don't even have a driver's license. And I mean, you would then have to find either a family member or a friend who can do transfers, pick up and drop off, and most people do not want to become involved in someone's life in that way. I mean, it's just a lot to try to keep constant connection because, they have their own lives. And most kids you can't just now put in an Uber or a Lyft,
Right.
I think people have that expectation, but most courts are like, why are we going out of your way when clearly you're the one who's at fault when getting the OWI?
Right. And sometimes just stopping that automatic process that's happening, the automatic suspension, the automatic, your license going away and having all these parameters put on you, just maybe delaying that for 3-4 months so you can get your wits about you. You can clear up some stuff in family court and you can plan.
Right.
That's worth
That's true.
just coming in and talking to a lawyer about doing.
Oh, 3 or 4 months I think would save a lot of people because, court cases take that long. So if you can show some improvement, sometimes, when I hear someone has an OWI and there's in the process, some defense attorneys say go into get AODA counseling. Do you suggest that?
Absolutely. Listen, not everybody drinks and drives. I know in Wisconsin we kind of joke about our alcohol use a lot, but not everybody drinks and drives. It is dangerous conduct, even if you're at that just 08, which used to be legal, right?
Mm-hmm.
If you had no outward exhibitions of intoxication, 0.08 is too much to drive.
Mm-hmm.
And so there's an issue there. If you're having more than a couple drinks after work to blow off steam or to try to cope with your divorce situation, that's something that you should talk to somebody about, either your attorney in depth, and if we reach our limit, then talking to a certified counselor about here's what's going on, here's how I've been addressing it, what are some things that I can do to be a little more proactive that doesn't put me in bad legal trouble or may have negative effects on my family situation.
Okay. Well, Dan, I know you said you do a lot of OWI and other drugs. What does your practice all entail?
My practice is about 80% criminal defense, and that's broken up into state courts, municipal courts, and federal courts. And it really runs the gamut anytime that law enforcement's involved. So about a third of it's domestic violence, a third is OWI, and then a third is what I call drugs and guns. I do have kind of a niche in Len Bias homicides, which are just as serious as they sound. Len Bias was a basketball player in the 1980s who overdosed on cocaine, 1987, I believe. The governments across the country responded by passing laws that say if you deliver a drug and someone dies as a result of using that drug, we're going to charge you with homicide.
Wow.
The unforeseen consequence of this is that more and more addicts are being charged with homicide offenses only because they were engaged in addict-like behavior, which means they and another addict went out to score drugs, they came back, they used it together, one of them died, the other lived. The person who died is now a victim of homicide, the person who lived is being accused of homicide, when really they were on the same moral plane just
Right.
hours ago. So I've really delved deep into that. I won a homicide trial in September on one of those cases, and I have those statewide now. It's really unfortunate. The opiate epidemic has changed our generation. In terms of the overdose deaths and the peoples whose lives and families are being destroyed by opiates, and really I'm trying to help just my clients try to get through it and become productive people on the other end of it.
Wow. And just out of curiosity, when you're charged with any drug crime, what are the bail conditions different?
Well, the bail conditions will be sober. Sometimes there are pretty onerous restrictions on who you can associate with, what you can do, but also checking in with a pretrial monitoring service. So you have to come in once a week, twice a week, and essentially pee in a cup, provide a urine analysis to make sure that you're maintaining sobriety. But the bigger thing is stigma, right? You've been charged with, even if it's marijuana. Marijuana is legal in many states, but not here. And many employers, if they've got, they're not supposed to do this, but we know they all do, looking on CCAP, if you have candidate A who has a clean record, candidate B who has a recent THC conviction or just arrest, who do you think they're going to hire?
Right.
So it's important, if you have any defenses to that, to hire an experienced attorney to try to beat down that case, or at least reach a resolution that you can live with.
Right, and I think well, a lot of times when we see clients in divorce court, they have seen their spouse struggle, or they've been struggling with addiction for so long that everyone involved is kind of tired. So there's a lot of back and forth and fighting. And so I think sometimes it's kind of still hard to have that conversation of you need to go to counseling, you need to get yourself clean, not just because you have an open criminal case and not because we're going through divorce, but it's really in your best interest and our kids' best interest. Because in divorce court, say your addiction has become overwhelming and taken over your life, you're not working, well, they're not going to cut you any credit as far as support from your spouse, because they're going to say, you know, you basically are causing the reason why you can't become self-supporting. I think, and you know, they're still going to want you to provide for your kids. They're still going to say you have to go out there and work. And just all of it. If there's marital waste of an estate because you were supporting an addiction, I mean, it just gets bad and worse for the family if you're not helping yourself by getting clean and finding ways to enter into treatment or get some services to help you out. So it's not just, we're here just to give you tips, because Dan is very clear in that he thinks the best way for you to stay out of it is not to get involved in any of these things. But he's here to help make sure if there is a defense that you can definitely use that to either get rid of a case or make sure cases never get resolved. But, you know, he and I both see this stuff all the time, how it can really impact your life long term. And for your just health, you need to find a better solution. So Dan, if someone needs you because life happens, they can find you. Your website is defensewisconsin.com, and I will put a link at the bottom of this video and also include information at the end and at the bottom of this blog. Do you set up consultations? What does it look
Absolutely.
like?
I do free consultations. You'll come right here. You'll sit where you're sitting. We will hash it out. You'll have my best opinion about what we should do. We can have a half hour, up to an hour of a free consultation, and then you really decide whether or not you want to retain me. I'm fine to do that. The best way to contact me to arrange a in-person consultation is 414-921-1945, and I'll be glad to help you out.
And I appreciate Dan for taking time out of his busy day. And I know he's doing this only because he's passionate about the work that he does. I know how great he is in court, and I know that he will give you any great advice. You just have to schedule the time with him. And again, we'll include that information. So thanks everyone for watching. Thanks Dan for appearing today. And I will see you guys next time on Sterling TV. Have a great day.